there are electricity bills to show. I have them. Electricity bills to show that out of the 3, 2 don't even stay there. The meter reading is 0. There was a Middleton Manor Association which was there, which was being run by one of these representatives of these petitioners. Now, they wanted to go and claim a particular terrace which in the deed was referred as a common area. Order 1 Rule 8 suit was filed by all the other members of the other unit owners in this suit. This is the one that's suppressed. In that suit in City Civil Code, we get an injunction that you cannot claim what is a common area as that to be yours. A terrace is a common area, which is really the meat of the issue here. That suit is naturally, understandably suppressed. They filed another suit saying this association, you can't, it's an informal association, you can't go ahead and run or manage this particular this building at all. We take out an application there saying these 4 who have come before your lordship today have a total outstanding of about 13 lakhs towards common area maintenance that they have not paid. So what they do is they keep it locked. One person's daughter lives in one of these and the others are locked. I'll show those electricity bills. They don't pay the common area maintenance. When the association, before this apartment owners was formed, when the association goes, they say we don't recognize you, although one of them was a part of the initial formation of the association. They say we don't recognize you, we will not pay. Then they file a suit. In that suit, we come and disclose that now there's an apartment owners under the 74 Act. Please make the payment that you're liable to pay in terms of the meetings that your lordship has just asked my lord whether meetings were held. Those meetings were held, they were put on notice, they have pictures where because it's locked, I have a person going and standing there. Form E was served. A bigger consideration, my lord. There is not 1 penny that has been paid from 22-23 by this. So this stay that Mr. Banerjee seeks from your lordship today is to ensure that there is complete anarchy and they don't make any payment. Not a penny has been paid towards common area maintenance. Now, with regard to this aspect of first, the basis and that suit gets suppressed. The first suit.
No, but then why from 1997
with extreme humility, kindly come back to the first judgment that was shown. Possibly this should have been pointed out. Not kindly have a look at paragraph 30. Legally, there could be and I very responsibly make this submission, kindly have a look at paragraph 30. The right law was probably not cited before my Lord Justice Bhattacharya. Kindly have a look at paragraph 30. Having not done so, just line about 4 from top, paragraph 30, sorry my Lord.
Yes.
Having not done so for the inordinately long period of 13 years from 2011, when the completion certificate was issued till 2024, then it's held to be ex facie barred. But what should have been, what are you doing, Zoe? Give me the notification by which the amendment came. What should have been pointed out, Lord? Kindly have a look at this notification. This amendment to Rule 2A, which prescribed 3 years. I had a copy though. This amendment to Rule 2A, your lordship will see amendment 1, Rule 2A, period for submission of Form A. This amendment of 3 years comes only in 2016. So the learned single judge was under the impression that delay he counted from 1994. This provision has come into the books only in 2016. Come down. In 2016. So this analysis, with extreme humility, does not take into consideration how this time period is going to be considered for properties in respect of which clearance certificate has come before 2016. This was not pointed out. Also, this is something that your lordship will have to be troubled with, because here the analysis in that judgment is 2011 you got or 2013 you got your completion certificate, 11 years you don't do it. What is the effect of this or the interpretation of this 3 years period? That the judgment does not consider. Because the books or this statute is amended only in 2016. So all properties which have received their completion certificate prior to 2016 and 3 years have lapsed.
What was there prior to the amendment? Was any time
Not
limit?
there. So now, Your Lordship will look at the judgment. I'll show one same judgment, but the same on a single judge, where Your Lordship remembers my Lord Justice Dotto's judgment. He struck down a rule because there was a dichotomy between the provisions of the Act and the provisions of the rules. The Act says the Act shall apply with regard to all majority. The rules came up and said either or. So the rule was struck down by Justice Dotto, saying this is an unworkable situation. I cannot harmonize and read this. So that rule is struck down. So in 2015, the rule was amended, where Your Lordship would now have noticed that earlier it was all the owners. Now it's become majority of the owners. So from 2015 onwards, to counter Ruidas Devnath, the amendment is brought, which is in the nature of a clarificatory or a validation amendment, that now majority of the owners also can do it. This amendment gets challenged before my Lord Justice Bhattacharya. He dismisses the application and rejects the challenge to the virus of that new amended rule on the ground that the object of the Act is to encompass within it as many properties as it possibly can be. Because it's a beneficial legislation looking at the class at which the statute is to operate or in respect of which it's to operate. Because now majority can go, otherwise situation like Mr. Banerjee's clients is going to come up, where you have an association, he goes files in suit saying you can't do it because you're informal association. I go under this act, they said you can't do it under this. So to remove this, the learned single judge holds that looking at the Act, this amendment will have to be allowed, because now just some erring minority members will not be able to withhold the registration under the Act. Properties must come in. This, the other judgment that Mr. Banerjee has relied on, that this 2016 amendment was never pointed out. The learned single judge was under the impression that from date of completion, but Your Lordship will have this slightly arduous task of interpreting this at all, this provision. Because the first question that fell from the court.
No, I got it. Now you tell me whether notices were issued
Yes,
to
yes,
everybody.
notices were issued persons when he doesn't even reside there. I'll be able to show for me. And there have been so many meetings.
He may not reside, but that does not mean
I'll be able to show.
that his right will be extinguished.
Correct.
His property is there.
100%. And if I may say this in a slightly colloquial way, the honey lies in that terrace, which is the subject matter of the first suit, which gets suppressed here.
What is the terrace used for?
Well, that terrace, so there's a large terrace.
Yes.
It's in 3 parts. 2 parts are stated to be common areas in all the deeds.
All right.
He has this one part of the 2 parts, let's say A, B, C. He has one part of A and B as an extension of his house. He tries to cover it and put tiles. This part, the remaining apartment owners, by way of an order 1 rule 8, we go and file the suit saying you can't treat this. He suffers an injunction saying this is a common area, because the deeds of all the other apartments ex facie shows that this is a common terrace. So there we also ask him to make payment of the dues of the association. He files a second suit saying this is an informal association, you have no right to run the premises. We go register ourselves here. Now he has notice in May. But by exchange of letters, Your Lordships have held exchange of letters does not postpone the cause of action. From 2013 onwards, Your Lordships have held that. I'm sure there were judgments before that also. So from May, he doesn't come. May is his declared date of knowledge. He comes up in December, the writ is filed. January, we're moving. If I'm not mistaken, more than 2 of such meetings have been held. And in such meetings, he has been asked to make payment. He doesn't go for any of these meetings. These notices also he gets. For these meetings that are to be held there also. And These
Does he receive the notices?
Mulad, I will have to
Receive
check
the
that, but we go, or me and all will be able to show he's received.
Is received?
Yes, yes.
For the petitioners personally or their representatives or something?
That I'll have to check, Mulad.
All right.
But I will be able to show that he had full notice and knowledge of this. And this is a person, Mulad, I'm equipped with judgment, but it's too hackneyed. That a person who comes and claims or invokes an equitable jurisdiction will first have to be not a defaulter himself. This is 3 people who've come forward out of a group of 13. Just 3 are coming and the remaining all 10 I'm representing. Who are saying that you let this property go back to a state of anarchy. Why? He wants that injunction today. Also, in fairness, Mr. Banerjee really does not press the injunction. But he wants that injunction today to resuscitate his other suit. To resuscitate his other suit. Because in that suit, we've taken out a 7-11 saying your suit is now bad, we have a formal association. So he gets to stay here. He goes there and he says, look, I have no one to pay to, so I'm not going to pay. So as long as this goes on.
Yes, I followed. State, I would like a report from you also.
Will allow me short, but some time to file an affidavit. It will be on documents.
I would like to have an affidavit from you.
So that whatever the petitioners have submitted is the part of the representation at page 110.
Did you consider it? Where is it?
And we have sent a notice.
When?
On 27 December. Very well. Now.
The representation is of May.
15 December. Today, whatever Mr. Banerjee submitted is...
Which Banerjee?
You have to point out.
Already a part. Kindly comes to page 110.
110?
Yes.
Yes, 10th of December.
So, here your lordship can see page 112, Form E, section 10A, Rule 2A. Whatever he has submitted today is already a part of this representation. On that, we have already acted upon and issued a notice on 27 December.
When is the hearing? Including copy of the letter. Submit a written reply. Dispatched only on the 31st of December. I don't think they have received.
My clients have received it.
Nobody has received. See, 16th of December, this writ petition is filed and copy must have been served upon you. Where is the affidavit of service? Where is the affidavit of service? And it is only thereafter that you jump into actions. Yes, after receiving the copy of the writ petition. Now 27th, a letter is prepared and it is dispatched on the 31st of December. Today we are on the 3rd. Possibly they have not received it. And what is your letter? Submit a written reply. The association, your client, has been directed to submit a written reply to the authority in this regard within a fortnight from the date of receiving. Hand over a copy to them also so that they get to know what is there.
No, I should do that.
What did your clients do after receiving page 56? 17th of May? Nothing. I understand you cannot improve.
There I, J, A and L. If you lordship see that page 52, you have submitted to the implementation only.
Yes, he's made submission. Whatever is there in the representation, he's made submissions on that.
If there is
No, IG is not an interim model, but prayer C is with regard to his representation. Main prayer
H is there.
Main prayer. Representation.
Prayers and
Please come.
the Lord's pleasure, my lord, that I give a rejoinder, my lord, is...
Interim order?
Yes, my lord, I want to... Interim order, my lord, with regard to, my lord, the certificate and any consequences. Because if I can just reply, my lord, two submissions. One, my lord, the 2016 amendment, really, my lord, would not make a difference. Because, my lord, the 2015, it came actually in 2015, my lord, where, my lord, section 2 was also amended. And, my lord, that says prescribed period, then 2A said 3 years. Even if we accept, my lord, Mr. Banerjee's argument to be correct, then, my lord, he is more under obligation from, my lord, 2016 to have that registered, my lord, within 3 years. That has also not been done.
No, that I'll be able to...
No, I'm just... May I just...
That it's not mandatory.
That's one. My lord, there's no question on the law. And, my lord, there's another submission. My lord, I'm so sorry. My lord, he's... Apart from prejudicial aspects saying that suits and all that, But civil suit can't be defeated. My lord, now him taking a step, my lord, illegally register, my lord, an apartment ownership under the Apartment Ownership Act. It, my lord, works both ways. He can't, my lord, also defeat, my lord, whatever rights are pending there.
The petitioners are aggrieved by the act of the competent authority in registering the Apartment Owners Association
Oh, that is received.
and issuing the registration certificate under the provisions of the Association of Apartment Owners. Now, under the provisions of the West Bengal Apartment Ownership Act, 1972. Stop. A representation before the competent authority was made in May 2024, followed by further representation in December 2024. Stop. None have been answered till date. Stop. The petitioners pray for interim orders restraining the association from taking any steps pursuant to the registration certificate that has been issued. Stop. The learned counsel representing the private respondents submits upon instructions that there has been gross suppression of material facts. Stop. There are 2 civil suits pending in between the parties. Stop. The petitioners have approached this court long after the cause of action arose. Stop. The learned advocate representing the state respondent submits that a notice has already been issued by the competent authority dated 27th December 2024, addressed to the President of the Middleton Manor Apartment Owners Association for submission of a written reply within a fortnight from the date of receiving the letter. Stop. A copy of the letter dated 27th December 2024 has been handed over in court today by the learned advocate representing the state respondents, wherefrom it appears that the said letter was dispatched only on the 31st of December 2024 and the same is yet to be received by the recipient. Stop paragraph. The court has heard the parties in details. Stop. It appears that the writ petition cannot be decided without granting opportunity to the respondents to file their affidavits. Stop. The respondents are accordingly directed to file affidavit in opposition by 24th of January, reply if any by 7th of February. Liberty to mention the matter for hearing immediately on completion of affidavits. Stop. The affidavit of the state shall include all documents which led to the issuance of the certificate of registration in favor of the association, including the notices which may have been addressed and sent to the petitioners. Stop. Next. The prayer for interim order made by the petitioners cannot be allowed because it appears that the petitioners got knowledge of the registration way back in May 2024, but has come up with the writ petition only in the month of December 2024. Stop. The court intends to decide the matter only after hearing all the parties upon exchange of affidavits. Stop. Very well, no further.
Very good.
Service is taken on record.
Some protection will provide us, otherwise if they continue with the...
Will be allowing us repeating.
No, why allowing?
What type of protection?
That no further on the basis of this meetings and all that if they hold.
This is only owners association meeting, your suit is pending, your right is protected.
No,
here also.
The suit, they will show this and my learned friend is submitting, he'll show this and say, sorry, you can't say anything. He's surprised.
No.
He can't say anything. No, I mentioned it. That's not correct. Some protection will kindly provide. Otherwise,
I will not take benefit of this order.
There is no in this.
That the court is not entering into the issue of title or ownership of any of the areas involved in the subject instrument.
Yes,
and the writ petition is only restricted to the issuance of the certificate of registration by the competent authority.
That should suffice for Mr. Grateful. The only thing